So the police have now released details of the charge sheet against Kanhaiya Kumar, Umar Khalid, Anirban Bhattacharya and others in the JNU sedition case from back in February 2016. Now, if this is in fact, and this document which we've now received from the police shows the evidence which they've got, which they're using to prove their case against these guys. Now, if this is all there is, however, this raises serious questions about whether there's any chance of a successful prosecution. Now, why is this? The test for sedition under section 124A of the Indian Penal Code is very strict. In 1962, a constitution bench of the Supreme Court held that there has to be an incitement to violence or serious threat to public order before you can have a case of sedition. Only that's punishable. There's been subsequent case law which is built up on this, which is clarified, like the Arup case in 2011, the famous section 66A case, which clarified that there's a difference between incitement and advocacy. And then you even have a case cases which have clarified that it has to be an imminent requirement for violence, not some vague idea of a revolution being sufficient to constitute sedition. So if you just are shouting slogans at an event, that is not sufficient to constitute sedition. Even where people were shouting Khalistani slogans, in the Balwant Singh case, the Supreme Court held this was not amounting to sedition. So now let's go back to the evidence supposedly presented against Kanhaiya and the others. Now, at most, this is from what we can see in the police, in all the evidence which they have evidence of slogans by these guys which were anti-national, and that's it. That is all they have at this point. So that clearly seems to fail the test which the Supreme Court has laid down. There is no imminent incitement to violence. Even if we go by the doctored videos which were there of what happened, there was no imminent incitement to violence. There's an advocation of sort of revolutionary ideals, a conception of freedom, but that's not an attempt to bring down the state. So there is nothing which the police have, according to their own evidence, which seems to indicate what they're required to do by law. So what does this mean? Does this mean the trial court is just going to throw the charge sheet out? Well, in an ideal world, yes. But we normally see trial courts just go along with whatever the police say in these kind of matters. So it'll probably be up to the High Court or the Supreme Court to quash the charge sheet against these guys, maybe at this stage itself, or if necessary on appeal from a conviction. So what does that tell us about sedition here? I mean, this is a case which is a perfect example of the dangers of having a law like sedition and the threat it poses to freedom of speech. And this is something which the Law Commission has also recognized recently, and they've recommended that there needs to be a discussion about amendments to the law to at least bring about some safeguards. I mean, at the end of this is a law which was brought in by the United Kingdom in India before India became independent, and they have also struck this down because of the dangers to free speech. And it's something which to be considered, that perhaps this case could be the touchstone on which sedition is either amended or perhaps even repealed, given that we now have subsequent jurisprudence of the Supreme Court in the right to privacy case and in the 377 case, where the judges have said that there is no presumption of constitutionality for pre-constitutional laws. So there is a possibility that this case could perhaps be the touchstone on which sedition can be changed in India, and that would perhaps be the only benefit of this case going forward.